Question 1. During a major transformation where existing methods of dispute resolution are being reassessed, an international tribunal is considering a case involving a boundary dispute between two states. One state claims that a previously signed treaty clearly defines the border, while the other state argues that new customary international law principles, including historical usage and the principle of equity, should take precedence over treaties' strict wording. Under international law, which principle should guide the resolution of this dispute? A. Pacta sunt servanda, which mandates that treaties must be honored in good faith. B. Ex equo bono, which allows for equitable considerations to override strict legal rules. C. Rebus sic stantibus, which permits treaty obligations to be modified due to fundamental changes in circumstances. D. Utipositas juris, which prioritizes historical territorial boundaries established during colonial rule. Answer: A. Pacta sunt servanda, which mandates that treaties must be honored in good faith. Explanation: the principle of pacta sunt servanda, Latin for agreements must be kept, is foundational rule in treaty law as codified in Article 26 of the Vienna Convention on the Law of Treaties, ELT 1969. It dictates that treaties are legally binding and must be executed in good faith by all parties. This principle in stability and predictability in international relations. YA is correct. The treaty as written agreement between states takes precedence unless there is legal ground for its invalidation. Y. B is incorrect. While ex equo bono, Article 38(2) statute allows courts to apply equitable solutions, it requires explicit consent from both parties, which is rare. YC is incorrect. The doctrine of rebus sic stantibus. Article 62 ELT allows treaty modification due to fundamental changes in circumstances, but it applies only in extreme cases such as state collapse, which is not the case here. Why D is incorrect. Utipositas juris applies mainly in post-colonial contexts, e.g. Africa and Latin America, and is irrelevant unless the dispute concerns former colonies' borders. The International Court of Justice has consistently prioritized pacta sunt servanda in cases like the Qatar v. Bahrain 2001 maritime boundary dispute where the treaty's text was upheld over conflicting customary claims. Question 2. While analyzing the root causes of sequential problems in international humanitarian law enforcement, legal scholars debate whether a non-state armed group engaged in prolonged armed conflict should be bound by international treaties despite not being a recognized state party to them. Under international law, which legal basis best supports the claim that non-state actors must adhere to humanitarian obligations? A. Customary international law, which applies universally to both state and non-state actors. B. The Montevideo Convention, which establishes criteria for statehood, making treaties binding only upon recognized states. C. The principle of reciprocity, which holds that obligations exist only when both parties are bound by a treaty. D. State consent theory, which requires that only entities with state-like sovereignty are subject to treaty obligations. Answer: A. Customary international law, which applies universally to both state and non-state actors. Explanation: non-state actors, including armed groups, are bound by international humanitarian law (IHL) through customary international law, even if they have not ratified treaties. The Geneva Conventions, Common Article 3, 1949, explicitly apply to non-international armed conflicts, ensuring that all parties, including groups, must respect fundamental humanitarian principles. YA is correct. Customary international law evolves from widespread and consistent state practice coupled with opinio juris belief that the rule is legally required. Non-state actors are bound by IHL as seen in the ICEX customary international law study in cases like the Tadic case ICE 1995. YB is incorrect. The Montevideo Convention 1930 defines statehood but does not dictate treaty applicability to non-state actors. YC is incorrect. Reciprocity applies mainly in treaty law between states and does not justify IHL obligations, which are binding regardless of mutual consent. YD is incorrect. The state consent theory is principle of treaty law but does not override the binding nature of customary IHL. The ICE reaffirmed this position in Nicaragua v. States 1986, ruling that even non-signatory states and actors must comply with customary humanitarian norms. Question 3. In a situation where formal requirements conflict with evolving cybersecurity threats, a multinational corporation is accused of facilitating cyber attacks against another state. The affected state seeks to hold the corporation accountable under international law. Which legal principle is most applicable in determining state responsibility for cyber operations conducted through private entities? A. The effective control test, which requires proof that the state had direct control over the corporation's cyber activities. B. The due diligence principle, which mandates that states prevent harm originating from their territory even if committed by private entities. C. The corporate immunity doctrine, which exempts private entities from international law obligations. D. The sovereignty principle, which prevents any external interference. State internal affairs, including regulating corporations. Answer: B. The due diligence principle, which mandates that states prevent harm originating from their territory even if committed by private entities. Explanation: in cyber law and state responsibility, the due diligence principle requires states to prevent, stop, and mitigate harmful cyber activities originating from their territory even when carried out by non-state actors. This principle is reinforced by the Tallinn Manual on the Internet. Law applicable to cyber warfare, Tallinn Manual 2.0. Why B is correct. The due diligence principle derived from customary law holds that states must active cyber operations from their jurisdiction threaten other nations. The Aids-Corfu Channel case, 1949, established that states are liable for failing to prevent harmful acts emanating from their territory. YA is incorrect. The effective control test, Nicaragua. Aids 1986 requires high threshold of state direction and control over non-state actor, which is difficult to prove in cyber warfare. YC is incorrect. There is no universal corporate immunity doctrine in international law. States can regulate and hold corporations accountable. YD is incorrect. Sovereignty does not absolve state from responsibility for transboundary harm as seen in environmental and cyber law precedents. The International Law Commission's draft Articles on State Responsibility, 2001, also reinforced that states cannot ignore harmful acts by private entities under their jurisdiction if those acts affect other nations. Question 4. During a major transformation where existing methods of dispute resolution are being reevaluated, a newly formed international tribunal faces a jurisdictional challenge from a sovereign state. The state argues that it has not explicitly consented to the tribunal's jurisdiction and that its national courts should have exclusive authority over the dispute. The opposing party claims that the tribunal has jurisdiction based on provision that allows for arbitration of disputes between states. How should the tribunal resolve this issue? A. The tribunal should decline jurisdiction because explicit state consent is required in every case. B. The tribunal should assert jurisdiction if the treaty clearly allows arbitration, even if the state did not explicitly consent to this particular case. C. The tribunal should refer the matter to the International Court of Justice (ICJ) for an advisory opinion. D. The tribunal should allow the state to unilaterally determine whether it is bound by the arbitration clause. Answer: B. The tribunal should assert jurisdiction if the treaty clearly allows arbitration, even if the state did not explicitly consent to this particular case. Explanation: the principle of state consent is fundamental in international law, meaning a state cannot be subject to an international tribunal's jurisdiction without its agreement. However, states can give advance consent through treaties. If the treaty in question explicitly includes dispute resolution clause mandating arbitration, then the tribunal has jurisdiction. This principle is established in the Vienna Convention on the Law of Treaties (ELT), Articles 31-33, which governs treaty interpretation. Option is incorrect because explicit consent is not always required at the moment of the dispute. Prior treaty-based consent is valid. Option C is incorrect as ICJ advisory opinions are non-binding and cannot decide case directly. Option D is incorrect since state cannot unilaterally disregard binding treaty provision. This issue frequently arises in investment arbitration and international human rights cases where states challenge tribunal jurisdiction based on sovereignty arguments. Question 5. While managing a hybrid approach where timing issues affect international treaty compliance, a government ratifies a treaty on environmental protection but delays implementing domestic legislation. Meanwhile, a multinational corporation operating in the country continues activities that violate the treaty's obligations. Civil society organization argues that the treaty itself creates direct obligations on the corporation. Legal effect of the treaty under international law. A. The treaty is automatically binding on corporations once ratified. B. The treaty binds the state, which must take action to enforce it through domestic legislation. C. The treaty does not bind anyone until formally incorporated into domestic law. D. The corporation can only be held accountable if regional human rights court decides so. Answer: B. The treaty binds the state, which must take action to enforce it through domestic legislation. Explanation: under international law, treaties primarily create obligations for states, not private entities. States are responsible for implementing treaties domestically. ELT, Article 27. Party may not invoke the provisions of its internal law as justification for its failure to perform treaty. This means the state enact national laws enforcing the treaty's provisions before obligations apply to corporations or individuals. Option is incorrect because treaties do not directly impose obligations on private entities unless explicitly stated. Option C is incorrect as some treaties may have immediate effects in monist legal systems, e.g. France, but many require domestic incorporation. Dualist systems like the UK and us. Option D is incorrect because while regional courts can enforce human rights treaties, enforcement remains the state's responsibility. This issue is critical in environmental law and human rights, especially regarding corporate responsibility in climate change and sustainability treaties, e.g. Paris Agreement, Kyoto Protocol. Question 6. In a situation where formal requirements conflict with emerging customary international law, a new regional coalition declares exclusive economic control over an extended maritime zone, arguing that evolving state practice justifies the claim. However, other states oppose this expansion, citing the United Nations Convention on the Law of the Sea, UNCLOS. What principle should govern the dispute? A. Customary international law always overrides treaty law when state practice changes. B. The coalition can claim the zone if enough states support the new practice. C. The UNCLOS treaty remains binding unless formally amended or overridden by consistent state practice. D. Regional agreements automatically take precedence over global treaties. Answer: C. The UNCLOS treaty remains binding unless formally amended or overridden by consistent state practice. Explanation: treaties like UNCLOS 1982 create binding legal frameworks, and customary international law cannot override treaty obligations unless a consistent, widespread, and legally recognized practice emerges. Opinio juris. The treaty norm itself allows for modification by evolving state practice. Option is incorrect because customary law does not automatically override treaties. ELT, Article 38. Option B is incorrect because mere state practice is insufficient without broad international acceptance. Option D is incorrect because regional agreements cannot override global treaties unless explicitly permitted. This issue is common in maritime disputes, resource rights, and geopolitical conflicts, e.g. South China Sea disputes. Question 7. When implementing backup procedures across various international courts, a conflict arises between a domestic law prohibiting the extradition of nationals and a treaty obligation requiring the surrender of individuals to an international tribunal. How should the state reconcile this conflict? A. The state must always prioritize domestic law over international obligations. B. The treaty obligation prevails, but the state may negotiate alternative measures. C. The state can ignore the treaty obligation if public opinion opposes extradition. D. The international tribunal has no authority to demand compliance. Answer: B. The treaty obligation prevails, but the state may negotiate alternative measures. Explanation: under international law, states cannot use domestic law as an excuse to breach treaty obligations. ELT, Article 27. In extradition cases, states often negotiate alternative solutions, such as domestic prosecution of the individual. Option is incorrect because treaty obligations take precedence in cases of conflict. Option C is incorrect since public opinion does not override legal commitments. Option D is incorrect because tribunals like the ICANN have legal authority under international agreements. This issue is prominent in international criminal law, e.g. genocide cases before the ICC. Question 8. During an emergency response where multiple areas are impacted, a state unilaterally suspends its obligations under a human rights treaty, citing national security concerns. Several NGOs challenge this action, arguing that the suspension violates international law. Under what conditions can a state derogate from human rights treaties? A. States can never derogate from human rights treaties. B. Derogation is allowed only if explicitly permitted by the treaty and necessary for national security. C. Any state can suspend treaty obligations at will. D. Derogation is automatically invalid if challenged in an international court. Answer B. Derogation is allowed only if explicitly permitted by the treaty and necessary for national security. Explanation: most human rights treaties e.g. IPA allow derogation during emergencies, but only if there is a genuine public emergency. Derogation is proportional and non-discriminatory. Certain rights e.g. torture prohibition remain non-derogable. Option is incorrect since treaties like ICA Article 4 allow derogations. Option C is incorrect because derogation is subject to strict legal tests. Option D is incorrect as courts evaluate legality rather than automatically invalidating derogations. This principle was tested in cases like v. UK ECA 2009 and the derogation measures post-9/11. Question 9. During a major transformation where existing principles are being challenged, a state invokes the doctrine of state sovereignty to justify non-compliance with an adverse ruling by an international court. The opposing party argues that the state is legally bound to comply based on customary international law and treaty obligations. How should this dispute be resolved? A. State sovereignty always takes precedence over international legal obligations. B. The ruling is binding if the state has consented to the jurisdiction of the court. C. Customary international law cannot impose obligations without explicit consent. D. The state can withdraw from the treaty to avoid compliance retroactively. Answer B. The ruling is binding if the state has consented to the jurisdiction of the court. Explanation: the principle of state sovereignty is fundamental in international law, but it does not override binding international obligations. If a state has ratified a treaty establishing an international court's jurisdiction, e.g., the International Court of Justice or the International Criminal Court, it must comply with rulings from the tribunal. Option is incorrect because sovereignty is limited by international obligations state has freely undertaken. Option C is incorrect because customary international law can impose obligations, particularly jus cogens norms, e.g. prohibition of genocide. Option D is incorrect. A state cannot retroactively escape legal consequences by withdrawing from Treaty IELTA, Article 70. Key case: Nicaragua v. United States, Eich 1986. The U.S. refused to comply with an Eich ruling citing sovereignty, but the court reaffirmed that binding international rulings prevail over unilateral claims of sovereignty. Question 10. While managing a hybrid approach where legal frameworks overlap, an international environmental treaty sets strict emissions limits, but a regional economic bloc adopts more lenient standards for its member states. A non-member state challenges the regional standards, arguing that they violate the treaty, which principle determines the outcome. International treaties automatically override all regional agreements. B. Regional agreements prevail if they better reflect state practice. C. The treaty prevails unless the regional standards are explicitly permitted. D. The regional bloc can set its own rules without international constraints. Answer: C. The treaty prevails unless the regional standards are explicitly permitted. Explanation: treaties take precedence over conflicting regional agreements unless the treaty itself allows for exceptions. Article 30 of the ECLT states that when a later treaty conflicts with an earlier one, the earlier treaty remains binding unless the states involved specifically modify their obligations. Option is incorrect because some treaties allow flexibility for regional standards, e.g., Paris Agreement. Option B is incorrect as state practice cannot override binding treaties unless it becomes customary international law. Option D is incorrect because regional blocs must still comply with higher international obligations. Example: European Union environmental regulations sometimes exceed international treaties, but they cannot violate binding agreements like the Kyoto Protocol. Question 11. In a situation where formal requirements conflict with emerging norms, a state refuses to recognize the jurisdiction of a newly established international court, arguing that it never ratified the court's founding treaty. However, the court asserts jurisdiction based on Unsecurity Council resolution. How should this issue be analyzed? A. The court lacks jurisdiction without the state's explicit consent. B. The Unsecurity Council can establish binding jurisdiction under its charter. C. Only the General Assembly can authorize new international courts. D. The state's refusal to recognize the court makes its rulings unenforceable. Answer: B. The Unsecurity Council can establish binding jurisdiction under its charter. Explanation: under Chapter Roman of the Uncharter, the Security Council can establish international tribunals, G. Eichte with binding jurisdiction over states even if they did not explicitly consent to the tribunal's creation. Option is incorrect because Security Council mandates under Chapter Roman are binding. Option C is incorrect because only the Security Council, not the General Assembly, has this authority. Option D is incorrect because international courts can enforce rulings through diplomatic pressure and sanctions. Example, the Eichte 1993 and Eichte 1994 were established without individual state ratification, but their rulings were enforced internationally. Question 12. When implementing backup procedures across various jurisdictions, a multinational corporation faces conflicting human rights obligations under national and international law. The company's home state has strict human rights laws while its host state has weaker protections. Civil society groups argue that international human rights law should apply. How should this conflict be resolved? A. The host state's laws always take precedence. B. The home state's stronger human rights laws apply extraterritorially. C. The corporation can choose the least restrictive legal framework. D. International law does not apply to private corporations. Answer. B. The home state's stronger human rights laws apply extraterritorially. Explanation. Many human rights treaties impose obligations on corporations through their home states, requiring them to uphold human rights even abroad. E.g., OAT guidelines on guiding principles on business and human rights. Option is incorrect because states must ensure their companies follow human rights laws internationally. Option C is incorrect because corporations cannot choose to ignore human rights obligations. Option D is incorrect as corporations are increasingly subject to international legal accountability. Example, Kiobel v. Royal Dutch Petroleum 2013 in the US. Supreme Court limited extraterritorial application but upheld corporate liability for human rights violations. Question 13. During an emergency response where national security is at risk, a state imposes mass surveillance measures that violate an international human rights treaty it has ratified. Civil society groups challenge these measures. What legal framework applies? A. The state can derogate from human rights treaties in any situation. B. The home state's stronger human rights laws apply extraterritorially. C. National security concerns always override human rights treaties. D. Human rights treaties cannot be suspended under any circumstances. Answer. B. The home state's stronger human rights laws apply extraterritorially. Explanation. Human rights treaties like the IPA Article 4 allow derogation only in emergencies and subject to strict conditions. Option is incorrect because derogations must be temporary and justified. Option C is incorrect as national security concerns must be balanced with legal protections. Option D is incorrect since some treaties allow limited derogation. Example, post 9/11 derogations under the European Convention on Human Rights were controversial but upheld under strict review. Question 14. While balancing obligations across multiple treaties, a state finds that two of its treaty obligations directly contradict each other. What legal principle applies? A. The most recent treaty prevails unless stated otherwise. B. The state can ignore both treaties. C. Customary law resolves all treaty conflicts. D. The treaties automatically cancel each other out. Answer A. The most recent treaty prevails unless stated otherwise. Explanation. Article 30 of the EAT provides that when two treaties conflict, the later treaty prevails unless otherwise agreed. Option B is incorrect because states cannot ignore treaty obligations. Option C is incorrect as customary law does not automatically resolve treaty conflicts. Option D is incorrect because conflicting treaties must be resolved legally, not cancelled outright. Example, trade agreements and human rights treaties often conflict, requiring legal reconciliation. Question 15. During a major transformation where existing principles are being challenged, a newly recognized government claims that treaties signed by the previous regime are no longer binding. The opposing state insists that treaty obligations continue despite governmental changes. What legal principle determines the outcome? A. A new government can always reject previous treaty obligations. B. Treaty obligations remain binding regardless of regime change. C. Only democratic governments inherit previous treaty obligations. D. A state must renegotiate all treaties after a governmental transition. Answer. B. Treaty obligations remain binding regardless of regime change. Explanation. The principle of state continuity in international law holds that treaties remain binding despite changes in government. The 1969 Vienna Convention on the Law of Treaties (ELT) Article 70 confirms that a treaty remains in force unless formally terminated under its provisions. Option is incorrect because a government cannot unilaterally reject treaty obligations due to a regime change. Option C is incorrect since all governments, regardless of their nature, inherit international obligations. Option D is incorrect because renegotiation is not required unless the treaty itself allows for it. Example: after the 1979 Iranian Revolution, Iran remained bound by international treaties, including those governing diplomatic relations. Vienna Convention on Diplomatic Relations, 1961. Question 16. While managing a hybrid approach where legal frameworks overlap, a multinational corporation is accused of environmental violations under both national and international law. The corporation argues that only domestic law applies. How should this conflict be resolved? A. International environmental law applies only if a treaty explicitly covers the issue. B. Domestic law always overrides international obligations. C. International law can apply if the state has ratified relevant treaties. D. Private corporations are never subject to international law. Answer: C. International law can apply if the state has ratified relevant treaties. Explanation: if a state has ratified international environmental treaties, e.g., the Paris Agreement or the Basel Convention, its domestic law must align with those obligations. National courts may apply international law if incorporated into domestic legal frameworks. Option is partially correct but ignores that customary international law may also impose obligations. Option B is incorrect because states must incorporate international treaties into their domestic laws. Option D is incorrect since corporations can be held liable under international environmental and human rights law, e.g., Shell's liability in Dutch courts for environmental harm in Nigeria. Example: in Agenda Foundation v. the Netherlands, 2019, the Dutch Supreme Court ruled that international human rights law required the government to take stronger climate action. Question 17. In a situation where formal requirements conflict with emerging norms, a regional organization adopts a human rights charter that contradicts a United Nations convention. A member state challenges the contradiction, claiming the regional agreement is invalid. How should this be resolved? A. The unconvention prevails as it represents universal legal standards. B. Regional agreements override international conventions for member states. C. A state can freely choose which standard to follow. D. The regional organization has full autonomy in legal matters. Answer A. The unconvention prevails, as it represents universal legal standards. Explanation: under Article 103 of the UN Charter, obligations under the UN framework take precedence over other international agreements. Regional treaties must comply with UN conventions and cannot reduce protections guaranteed by them. Option B is incorrect because regional agreements cannot contradict higher international norms. Option C is incorrect as states cannot selectively ignore UN obligations. Option D is incorrect since regional autonomy does not exempt states from global legal commitments. Example: the European Court of Human Rights applies both the ECA and UN treaties, ensuring compliance with international human rights law. Question 18. When implementing backup procedures across various jurisdictions, a corporation faces data protection requirements under both the national law and the General Data Protection Regulation (EDR). The national law allows broader data collection, while the GDR is stricter. What principle applies? A. The less restrictive law prevails to avoid trade barriers. B. The stricter regulation applies if the company operates in both jurisdictions. C. The corporation can choose the law that benefits its business model. D. GDPR applies only within the European Union. Answer: B. The stricter regulation applies if the company operates in both jurisdictions. Explanation: GDPR applies extraterritorially to any company processing EU citizens' data, regardless of where the company is based. This follows the principle that stronger legal protections prevail over weaker ones when applied extraterritorially. Option is incorrect because data protection laws are not overridden by economic concerns. Option C is incorrect as businesses cannot pick and choose regulations. Option D is incorrect because GDPR applies globally when EU citizens' data is involved. An example: Meta, Facebook, FIS GDPR fines even though it is US-based company because it processes EU data. Question 19. During an emergency response where national security is at risk, a government imposes censorship laws that conflict with an international human rights treaty it has ratified. What legal principle applies? A. The treaty prevails unless the state formally derogates from it. B. National security always takes precedence over human rights. C. International law does not apply in national security matters. D. Censorship laws automatically override international agreements. Answer A. The treaty prevails unless the state formally derogates from it. Explanation. Treaty obligations remain binding unless a state formally invokes a derogation clause under instruments like the IPA Article 4. Even in emergencies, restrictions must be proportionate and necessary. Option B is incorrect because human rights treaties remain applicable even in crises. Option C is incorrect as international law explicitly regulates national security measures. Option D is incorrect because treaties do not become void due to unilateral national security claims. Example, post 9/11 U.S. security policies faced legal challenges under international law for excessive restrictions on free speech and due process. Question 20. While balancing obligations across multiple treaties, a state is bound by two conflicting trade agreements. What principle determines which agreement prevails? A. The most specific treaty applies. B. The most recent treaty prevails unless otherwise stated. C. Customary law always resolves treaty conflicts. D. Conflicting treaties automatically cancel each other out. Answer B. The most recent treaty prevails unless otherwise stated. Explanation. Under Article 30 of the ELT, if two treaties conflict, the later treaty prevails unless otherwise agreed. This ensures legal clarity when states enter into multiple agreements. Option is incorrect because specificity does not automatically determine precedence. Option C is incorrect as customary law applies only if universally recognized. Option D is incorrect because treaties remain in force unless formally terminated. Example, the WTO's trade rules sometimes conflict with regional agreements like NAFTA requiring legal reconciliation. Question 21. During a moment of heightened scrutiny where the global community demands accountability, a state is accused of violating the Genocide Convention. The accused state argues that domestic law does not recognize the crime. What principle applies? A. Domestic law takes precedence over international law. B. The state must modify its legal system to comply with the treaty. C. International law applies only if enforced by the UN Security Council. D. A treaty is not binding unless explicitly implemented in domestic legislation. Answer B. The state must modify its legal system to comply with the treaty. Explanation. Under Article 27 of the Vienna Convention on the Law of Treaties E8, a state cannot invoke domestic law as a justification for failing to perform treaty obligations. The Genocide Convention 1948 requires all signatories to criminalize genocide, meaning states must align their legal systems accordingly. Option is incorrect because international treaties override national law when a conflict arises. Option C is incorrect since the UN Security Council is not required for enforcement. The International Court of Justice and International Criminal Court also have jurisdiction. Option D is incorrect because many treaties apply automatically without additional domestic legislation. Example, in Bosnia v. Serbia 2007, the ICJ ruled that Serbia violated its obligation under the Genocide Convention by failing to prevent genocide in Srebrenica. Question 22. While navigating through a legally complex dispute where sovereignty is contested, a newly declared state seeks international recognition. What determines whether it qualifies as a state under international law? A. Recognition by powerful states automatically grants statehood. B. A state must meet the Montevideo Convention criteria. C. A state exists only if admitted to the United Nations. D. Statehood requires democratic governance. Answer B. A state must meet the Montevideo Convention criteria. Explanation. Under the Montevideo Convention 1933, an entity qualifies as a state if it has a permanent population, a defined territory, an effective government, the capacity to enter into relations with other states. Option is incorrect because recognition by powerful states alone does not determine legal statehood. G. Taiwan functions as a state but lacks recognition. Option C is incorrect because unmembership is not required for statehood. G. Switzerland was neutral and did not join the UN until 2002. Option D is incorrect as statehood does not depend on the type of government. Example, South Sudan became a state in 2011 after meeting the Montevideo criteria and gaining widespread recognition. Question 23. In a scenario where historical grievances lead to territorial disputes, two neighboring states claim sovereignty over an island. One state argues historical ownership while the other claims continuous administration. What principle helps resolve the dispute? A. The state with the strongest historical claim prevails. B. Continuous and effective administration determines sovereignty. C. The dispute is settled only if both states agree on arbitration. D. The unautomatically resolves territorial conflicts. Answer. B. Continuous and effective administration determines sovereignty. Explanation. International courts, such as the Aichi, prioritize effective and continuous administration over historical claims. This follows the principle of effective rights, where the state exercising actual control over the territory often prevails. Option is incorrect because historical claims alone do not establish sovereignty. Option C is incorrect as courts can hear disputes even without mutual consent in some cases. Option D is incorrect since the UN does not automatically resolve disputes. States must submit cases to international courts or arbitration. Example, in the Pedro Branca case, Singapore v. Malaysia, 2008. The Aichi ruled in favor of Singapore because it exercised continuous authority over the disputed island, despite Malaysia's historical claim. Question 24. During a period of diplomatic tension where security concerns dominate legal discussions, a coastal state extends its territorial sea beyond 12 nautical miles. Another state objects. What principle applies? A. A state can extend territorial waters if it feels threatened. B. The UN Convention on the Law of the Sea, UNCLOS, limits territorial seas to 12 nautical miles. C. Each state determines its own maritime boundaries. D. Territorial seas automatically extend with military control. Answer. B. The UN Convention on the Law of the Sea, UNCLOS, limits territorial seas to 12 nautical miles. Explanation. Under UNCLOS 1982, a state's territorial sea cannot exceed 12 nautical miles from its baseline. Any claims beyond this are illegal under international law. Option is incorrect because security concerns do not justify unlawful expansion. Option C is incorrect as maritime boundaries are legally regulated, not subject to unilateral decision. Option D is incorrect because military control does not change legal boundaries. Example, China's claims in the South China Sea exceed UNCLOS limits and have been ruled illegal by the Permanent Court of Arbitration 2016. Question 25. In a phase of legal adaptation where evolving technologies challenge existing frameworks, a state launches cyber operations against another, causing economic damage. The targeted state claims it is an armed attack under the UN Charter. What determines whether cyber operations constitute an armed attack? A. Any cyber attack qualifies as an armed attack. B. The attack must cause physical destruction or significant harm. C. Only kinetic military actions count as armed attacks. D. Cyber operations are never covered under international law. Answer. B. The attack must cause physical destruction or significant harm. Explanation. The Aichi Charter, Article 51, define an armed attack as an action causing significant harm similar to conventional military force. Cyber attacks may qualify if they result in severe economic or infrastructure damage. Option is incorrect because not all cyber attacks meet the threshold of an armed attack. Option C is incorrect since international law recognizes non-kinetic forms of warfare. Option D is incorrect as cyber warfare is increasingly covered by legal frameworks. Example, in 2010, the Stuxnet cyber attack damaged Iran's nuclear program, raising legal questions about cyber warfare under international law. Question 26. When determining liability in a highly interconnected global system, a transnational corporation is sued for human rights violations in a foreign country. Can international law hold corporations accountable? A. Only states are responsible under international law. B. Corporations can be held liable under international human rights law. C. International law does not regulate corporate conduct. D. Human rights treaties apply only to governments. Answer. B. Corporations can be held liable under international human rights law. Explanation. International law increasingly recognizes corporate accountability, particularly under instruments like the Guiding Principles on Business and Human Rights and national laws enforcing extraterritorial liability, e.g. the U.S. Alien Tort Statute. Option is incorrect because corporations can be sued for international violations. Option C is incorrect as global legal standards regulate corporate actions. Option D is incorrect since corporate responsibility is expanding under human rights law. Example, Shell was held liable in Dutch courts for environmental damage in Nigeria 2021. Question 27. As global security dynamics shift, a state invokes the doctrine of self-defense under Article 51 of the UNCHARTA after launching a military strike against another country. The international community questions the legality of the action. What factors determine whether self-defense is justified? A. A state can always use force when it perceives a threat. B. Self-defense must meet the principles of necessity and proportionality. C. The UN Security Council must approve all acts of self-defense in advance. D. Preemptive self-defense is universally accepted under international law. Answer. B. Self-defense must meet the principles of necessity and proportionality. Explanation. Under Article 51 of the UNCHARTA, states may use force in self-defense only if an armed attack occurs. However, customary international law further requires that the self-defense must be both necessary and proportional. Necessity. The attack must be imminent with no other means of resolution. Proportionality. The response cannot exceed what is neutralize the threat. Option is incorrect because subjective perception of threat does not justify force under international law. Option C is incorrect since states can act in self-defense without prior Security Council approval, but they must report their actions immediately. Option D is incorrect because preemptive self-defense remains controversial. While some argue for it, others say it violates the UNCHARTA. Example, the 1986 U.S. strike on Libya, Operation El Dorado Canyon, was controversial as the U.S. claimed self-defense, but critics argued it lacked necessity and proportionality. Question 28. When assessing the complexities of international legal responsibility, a state is accused of violating the prohibition on torture under the Convention Against Torture (CAT). The state argues that it did not directly commit the acts, but its agents were involved. What principle applies? A. A state is responsible only for actions it officially authorizes. B. A state is responsible if its agents commit or condone torture. The individual officials, not the state, bear liability under international law. D. Torture is only a violation when conducted on a state's own territory. Answer. B. A state is responsible if its agents commit or condone torture. Explanation. Under the Convention Against Torture, 1984, and customary international law, a state bears responsibility if its officials or agents commit, condone, or fail to prevent torture. Even if the government did not explicitly order the act, it is still accountable. Option is incorrect because states are liable for unlawful actions by their agents even if not explicitly authorized. Option C is incorrect as both individuals and states can be held responsible for torture, e.g. through the International Criminal Court or regional human rights courts. Option D is incorrect because states can be responsible for torture conducted anywhere under their jurisdiction or control, e.g. occupied territories or detention centers abroad. Example, the European Court of Human Rights held Russia responsible in Isaeva v. Russia 2005 for failing to prevent torture by its security forces. Question 29. As economic interdependence grows, two states sign a free trade agreement, but one later imposes high tariffs on the other's exports. The affected state claims violation of international trade law. What principle applies? A. States can impose tariffs whenever they choose. B. Free trade agreements must be respected under the Pacta Sunt Servanda principle. C. The World Trade Organization has no jurisdiction over trade disputes. D. Tariffs are never allowed under international trade law. Answer. B. Free trade agreements must be respected under the Pacta Sunt Servanda principle. Explanation. The principle of Pacta Sunt Servanda, agreements must be kept, found in Article 26 of the Vienna Convention on the Law of Treaties, requires states to honor their treaty commitments, including trade agreements. If a state imposes tariffs in violation of a free trade agreement, it breaches international trade law. Option is incorrect because tariffs must comply with trade agreements. Option C is incorrect. The WTO provides a dispute resolution mechanism for trade conflicts. Option D is incorrect since tariffs are allowed under certain conditions, such as anti-dumping measures or national security exceptions. Example, in 2018 the U.S. imposed tariffs on steel and aluminum, leading to disputes over whether they violated free trade agreements. Question 30. In a critical moment of international diplomacy, a state refuses to comply with a ruling by the International Court of Justice, arguing that it was not bound by the decision. Under what circumstances are Eicht rulings legally binding? A. Eicht rulings are legally binding only if a state explicitly consents. B. Eicht rulings are binding if a state has accepted the court's jurisdiction. C. Eicht rulings are non-binding and only advisory in nature. D. The Eicht has enforcement power to compel states to comply. Answer B. Eicht rulings are binding if a state has accepted the court's jurisdiction. Explanation. Under Article 94 of the UNCharter, Eicht rulings are legally binding on states that have accepted the court's jurisdiction. States accept jurisdiction through treaties that specify Eicht dispute resolution, explicit consent given for specific case, declaration recognizing Eicht jurisdiction as compulsory. Optional clause under Article 30 of the Eicht Statute. Option is incorrect because states agreeing to Eicht jurisdiction are legally bound by its decisions. Option C is incorrect since only advisory opinions are non-binding, not rulings in contentious cases. Option D is incorrect as the Eicht itself lacks enforcement mechanisms, but the Unsecurity Council can take action to pressure compliance. Example, in the Nicaragua v. United States case 1986, the U.S. refused to comply with the Eicht ruling, demonstrating the challenge of enforcement.